Hello, everyone. This is Gilbert Gelada. I'm talking to you here from Private Corporate Counsel. This is Tufts On Tax, where all your tax questions and answers are right here with Mr. T. Scott Tufts. When it comes to taxes and tax law and tax litigation, he's the master for that. So you can call him at 877-647-7887, and that's on a 407 number as well, area code 407-647-7887. You can email him at stufts@pcc.law. That's stufts@pcc.law. Or you can visit the website privatecorporatecounsel.com or pcc.law. Now you can subscribe so you continue receiving episodes from Tufts on Tax. Hello, Scott. How are you?
Hey, good to be with you.
Good to be with you, too. Now, today we are talking about the Biggins case. Federal tax whistleblowers. So before we go further on explaining the case, I want to ask if we can explain a little bit about the definition of whistleblowers and why we call it whistleblowers. And I know we went over it briefly in the past, but if you can explain more and simplify it to the audience, so
Sure.
just in case if they don't know.
All right, so the concept of let's do the concept first, then we'll come back to maybe what it means to blow a whistle. But
Correct.
A whistleblower is someone who wishes from the inside to report on or with someone with personal knowledge of someone violating the laws. And so depending on what laws we're talking about, the person that is coming forward is going to the government, the administrative agencies, or going forward in a brave and courageous manner, presumably, and is bringing forward violations of law that they have that they wish to do so, and they're doing so in the hope of also, invariably receiving an award for doing that. And so you have a question in many of the laws that we're talking about is how is it in practice implemented? And what I mean by that is it anonymous? Are there procedures to address how that whistleblowing is done? And invariably there are rules and conditions placed on it. And then the question becomes, are there procedures to facilitate the prosecution of someone? So there's so much more to this than just kind of the wrinkle we'll talk about today with the Biggins case, because what you have to know first is whistleblowing in general, which is you're ratting someone out, you are reporting something, violations of the law, and you're going to do that because what laws are you talking about? And then who do you go to report what you believe to be someone else violating a law? Okay? So that's the concept of blowing the whistle. You are, sitting in the town square, and you are blowing a whistle saying, hey, that person over there is violating the law. So in a way, you have to understand that in the context of whistleblowing, it's very difficult. Because if you think about it, there are other terms that someone might view that are less endearing. You might hear the word snitch, or you might hear a rat. You might hear those type of terms, and that really is why there is careful regard given in these laws to ways to assist in the process of bringing forward information. Many companies will have private hotlines to allow an internal employee to bring forward the concerns. Internally, many companies will have an internal procedure to handle those so that those are taken seriously. The hotlines often are anonymous. And then the question is, are you reporting from within and you're still let's say an employee of a company? What about that? How is that handled? And so that gets us to, in the context of taxes, we have IRS Form 211. That is for whistleblowing at the federal level, and it's got a lot to it. There's a new form out of the 211, a new version of the Form 211 that is out now, that are, folks who are looking at coming forward with whistleblowing, they need to know what is the criteria for a whistleblower, what is the requirements to receive an award, is it discretionary on the part of the government to pay an award, or is it mandatory? Well, if it's mandatory, what is the criteria for that? When you blow the whistle at the federal tax level, what is your role? How did you learn the information? How did you obtain the source information? Right?
So they just can't go and inform them. They have to be prepared to be questioned about all the details.
Well, and if you get it wrong, think about it. You say so and so's not done something, and so it's important in the process to get the good advice on how you're going about it. Make sure you're adhering to the process. The good news is that with all the agencies, based on what laws you're talking about in blowing a whistle, you then have to ask, are there procedures by which the process allows you to be deputized? And what I mean by that is, outside of the federal tax law, there's qui tam. We've heard this term, and you could be, a relator is the way I call it, and that you then can champion a case filed under seal, and then if it gives the government a chance to take the case up and pursue it. The current version of the federal whistleblower law for the tax law doesn't proceed on that basis. It has its own kind of way of doing it using IRS Form 211. The various states have their own approach as well.
That made me realize that we need to make a separate episode for whistleblower.
Yeah. So, but for purposes of today, the Biggins case,
correct,
is the Biggins v. Northern Ohio Medical Specialist case, LLC, out of the Northern District of Ohio Western Division, out on April 25th, 2024. And what we are interested in talking about today is a subset of the whistleblower law. That's Title 26 U.S. Code 7623. That's kind of the main section for whistleblowing. And then there's a subpart D as in dog, that is that was put in place by the Taxpayer First Act in 2019, I believe. And what it does is it was intended to protect whistleblowers who are employees coming forward and reporting on their employer.
Oh. Is this the case here?
Yes. So on Biggins, it's talking about and interpreting what the provisions are when a employer then, under this provision, is prohibited from terminating an employee in reprisal for any lawful act done by the employee to provide information regarding the underpayment of tax or any conduct in which the employee reasonably believes constitute a violation of the Internal Revenue laws or any provision of the federal law relating to tax fraud. So what is going on here? You are retaliated against because you bravely came forward to disclose a conduct that relates to tax fraud, or that is coming forward in the context of conduct that you reasonably believe constituted a violation of the law. So the important part there is that this provision also requires you to protect yourself from retaliation, and there's there's a section in the whistleblowing law that allows you to then go to the Secretary of Labor and file what they call a TFA claim, and that's Taxpayer First Act, so TFA, that says, hey, I'm going to file a complaint. But what they do is they want to give the Secretary of Labor the chance to review it and make sure that they look at it first. So you have this this is common in many of the whistleblower laws or the retaliation provisions. They want a chance to take a look at what's going on. All right. So the case, though, discusses the criteria of the Taxpayer First Act, and that is, you have to show that you engaged in protected conduct. You have to show that the defendants knew that of the protected conduct. Then you have to obviously discuss what was the adverse employment action, termination, or whatnot, and then you have to show that there's a connection there, right? That the retaliation occurred because you engaged in the protected conduct. You have to show it was a contributing factor. If you do that, then the burden will shift to the accused employer to then show by clear and convincing evidence that it would have taken the action anyway. So let's say they say, you may have been doing that, but we would have done it anyway. We would have gotten rid of you or done something to you. Then the onus at that point, if you meet the evidentiary burden, the defendant employer has to come back and rebut that and say basically that whatever adverse action was taken against you, it was done and would have been done anyway, something like that. Very, very high standard, clear and convincing evidence, very high standard. All right, so in Biggins, the effort was made to dismiss the case, and the argument was made by the defendant that they can't show that the defendant was that the plaintiff was engaged in protected conduct under the TFA, so therefore no way to recover, right? So they tried to throw the case out. And we've seen that before. Cases, when they're filed, there's an effort to throw the case out because it's argued that the proper grounds haven't been set. So the discussion of the case is interesting for our audience because it's dealing with defining some of these terms. What does it mean? What do you have to show? And some of that. And the question becomes, in interpreting it, what is objectively reasonable? It's a reasonable belief standard. And the case helps also understand that, when you're determining what is reasonable, the courts will be looking there under this provision, at least, for the reasonableness of the employee's belief, and it's going to depend on the totality of the circumstance. So they'll look at it, and that's very much a factual issue. So, this gets back to, what we say so often about the tax laws. People might want a simple answer. They might want something that's kind of very clear, cut and dry. And the reality is it's complicated. Taxes are complicated. Protecting yourself from retaliation and whatnot, there needs to be a careful regard for what does the law require you to show and for you to then do it. So this is true with all laws. If to determine whether you meet the laws or the protection that the laws wish to afford to you, you have to look carefully at the criteria and determine that you meet those criteria. So Biggins presents to us one of the first times we've seen an interpretation of this particular subsection of the whistleblower law. What I would just say is that when you're looking at the Form 211 and filling that out, and you are looking at the part of the form where you describe your relationship, and it will say, well, how did you come across the information? What is the nature of your relationship between you and the identified party? And one of those criteria would be you're an employee, right? You're from the inside, if you will, to blow the whistle, because that would be where you might have access to it. If you're an employee, in Biggins it was a controller, a financial controller, but what is it? What is the role that you had that allowed you to see and then blow the whistle? Meaning that how did the information come across your desk?
And what's that employee's position and involvement? Right. And how is that between, if it's something wrong and he's reporting it, but what about confidentiality?
Yeah. So this is a very important issue because
very touchy.
Yeah, very touchy, because you don't have to go, there are a lot of relationships, doctor patient, lawyer client, accountant,
Correct,
you go into all the professional relationships, that have a confidentiality component, and then you ask yourself, okay, you're going to take that information and blow the whistle on it. You know, ask yourself this: if someone were to say to you, you know, you have to keep this confidential, right? And it's a crime. Are you complicit in that crime because you're going along with it? So there, and you have to keep your mouth shut.
Correct.
You know, so there's a lot of issues with that, and you have to be well advised and to think through these things.
That's a good example, because if there is, because of that problem or that mistake happening, maybe a crime will happen, and then if you don't talk about it, then it grows, and then now we have a criminal case, and then why didn't you tell us?
Yeah, and look, if our ethical constraints as lawyers or other constraints from other, you know, professions, they might deal with, when is there an exception to your rules of privilege, you know, and protecting it? Because you could imagine that ethically there might be a scenario where one cannot allow something to go forward, even though it's their client. But at the same time, these are very difficult issues, because they have to, you know, you have to run the gamut of what is it. So, you know, you've brought up the idea of confidentiality or proprietary things or whatever. You have to get the good advice about what you're seeing, what you're observing, and the process. Because if you certainly have gathered in information of interest to law enforcement, it's certainly going to be of interest to law enforcement how you got it, and it's going to be important to know, is there a concern about the information that you gathered, right? I mean, look, there's you know, confidential informants who might assist in investigations where they can wear a wire, they can you know, assist law enforcement. So, you know, how information is obtained may not always be you know, you may not always know how it was done. But in this whistleblowing process, it's certainly expected that in the process they're going to ask, how did you get this information?
Correct. Yeah.
And is that information protected from product, you know? And so therefore there will be careful regard given, I assume, to how this information was obtained, but also, was it obtained lawfully, legally, and in fact, or is there a compulsion for someone to come forward? Because then if you haven't come forward with it, is that a problem, you know, that others have not?
That's interesting that you said, you mentioned something really interesting. You said, what if the problem is it turns to be criminal or something wrong, but you were not supposed to know this and you came across the information illegally, but you reported something that's happening that is illegal.
Right.
So
So
where do they draw the line here?
Well, the federal tax law actually allows and actually looks at whether or not you planned and initiated it at a very high level, kind of like getting into where were you the command and control of it, and then, or were you in a lesser role, right? So that might affect the level of your award. You might say, well, you were not the planning and initiating one, but you went along with it. Well, what happens if you went along with it, but then you backed out? Can you do something then? Can you like go along with it for a while and then blow the whistle?
Interesting.
Right? So can you be in the proverbial getaway car and then exit the getaway car and blow the whistle? You know, I mean, that's probably a terrible example, but the idea being that
it's kind of like that, yeah.
You know, the idea is that, you know, do you have to be the observer watching the getaway car?
Yeah.
Or you got to be the inside driver, the passenger, right? Can you be the policeman? that's watching this happen, whatever the right, the idea being that who you are is also important.
And I think wherever he's at, like you said earlier, the confidentiality, and you mentioned ethics. So I guess when it's something it's going to hurt others, and it is, and it's going to affect others, I guess the confidentiality here, it shouldn't be an issue.
Yeah.
Because...
one attitude with this is confidentiality. If you look at a lot of agreements, they carefully exempt out of the confidentiality agreement the ability to talk to advisors and people. And then even then, they may go further and say, and of course, it cannot apply by definition to legitimate acts, lawful acts, and so forth. In other words, there are provisions that I've seen drafted where they actually affirmatively embrace the exception to the rule of non-disclosure. Because one of the things that you can always look at is when you share tax information with the government, when you're a taxpayer, that's a one-on-one relationship, and that information is confidential between you and the tax authorities. So your information should not be shared, right? So that's kind of why you want to be careful with tax information in general, but it also kind of helps you see that it's kind of secure and private and personal between you and the, arguably the government. So if someone's reporting on it, they've gotten that information. And so how did they get it? Because if it was revealed, how was it revealed? And that could be a problem. So yeah, it's a thorny whatever, this is why it's not for the faint of heart, and it needs to get proper review, because it's, and then the other thing is the problem for whistleblowers is it's no picnic. And so I think at the end of the day, what we can say is, certainly for tax whistleblowers, the desire of Congress to embrace the whistleblower with laws that are intended to facilitate whistleblowing at a very large level has to be balanced against the reality of the circumstance. And that means that it's not easy being a whistleblower. The criteria have to be met. The forms have to be filed, and it's a process. And these things are not things that happen overnight. In the context of tax whistleblowing, awards, if they are to be granted, they're going to take, might take some time. And that's a whole nother issue. So I think at the end of the day, we just want to remember in this context, cases like Biggins that talk about the protection. So if you are bravely coming forward, you get the good advice about coming forward, or you're in a situation where you believe you're retaliated against, the point of this podcast is to let our folks know that there are anti-retaliation provisions inside the federal tax whistleblower laws, such that if you're an employee in an employer-employee setting, and you believe you've been retaliated against for having come forward, then there's some teeth in the law to protect you. And that's kind of what we were talking about with Biggins.
Awesome. I guess that's a wrap for us today, and we can talk more about
we'll get
whistleblowers.
Back. Yeah, we'll stay on it. It's pretty hot and heavy. So.
Yes, hot and heavy. That's the. Thank you, folks, for listening today. You can call us at 407-647-7887, and you can reach us at the same number, 877-647-7887. You can email Mr. T. Scott Tufts at stufts@pcc.law. That's stufts@pcc.law, or you can visit the website at privatecorporatecounsel.com. Please hit that like button and subscribe button if you want to listen to more episodes with Mr. T. Scott Tufts. Thank you and have a good day.